Good job.
And they're like, we don't have a cash register, so just post
I should have stopped by. That's so nice.
I was like, are you sure? And I was like, Olivia, why'd you say that?
Okay, so I am still working on the grading for this class. It is unfortunately the time of year when there's sort of a bottleneck with the course schedules that I'm in charge of and various it's not pricing. It's various things that need immediate attention that keep coming up with all that. And then of course, well, it's a busy time in the first year property class as well. So for those of you, easements and covenants, those of you who can remember that fondly. And so I'm working 7 days a week, long hours, but I just haven't been able to finish it up. I basically need the weekend of uninterrupted time to do that. So you will get those back next week. So I wish I had them for you, but I just don't. But I did want to go ahead and get out on Blackboard the material on the Stapleton Ridge project, which is going to be our next hearing. And that's in part because the hearing on Stapleton Ridge is the Wednesday right after we get back from spring break. Okay? And it's just the way that spring break falls. If spring break had been the following week, we would have done it before spring break, and then, and that's sort of usually how the timing goes. But it just turns out U of L put the spring break earlier this year, and so it is what it is. And so I want to give us plenty of opportunity to get going on that. And you all switch roles now, right? Everybody follow that. We'll talk about that after we go through some of the material, but I want to go ahead and get you focused on that. But now what's going to happen is we're going to go out to the suburbs and deal with residential development over by in Middletown on Floyd's Fork. And so that gives you a feel of land use and land development issues of a new residential subdivision on some environmentally sensitive lands. And what was proposed for that was a conservation subdivision, which can mean lots of different things. So one of the things we'll explore in this class is what exactly does that mean for Louisville, and is that how similar or different is that to other communities around the country and so forth. So anyway, I wanted us to keep moving, and I gave you all a fair amount of feedback after the hearing, so that should be good things to keep you developing skills and moving forward. But you'll get all the grades back next week. So, are there questions about any of that? Okay. All right. So today, the doctrinal material, substantive material, is takings, and we're doing this in two parts. And this is an important area. It is important to understand just sort of basic conceptual foundations, whether you're going to be a planner or a lawyer. These cases that we're going to talk about, the principles, the legal principles that are articulated in them, the legal tests are tested on the bar exam and on the AICP exam. So it's important material, and so we're going to go through this. For those of you who have had my property class, you will see some things that we already covered, but it's not going to be just the same material, because we are actually going to cover more cases and more concepts, and we're also going to go deeper into some of that. So if some of this is familiar, don't tune out, because there's more to it than what we covered in property. So, the basic concept is that the U.S. Constitution protects private property rights against certain exercises of government authority. And we have talked about procedural due process. We talked about substantive due process and procedural due process. We talked about the due process clause. We talked about the Euclid case in which that there was a substantive due process challenge to the constitutionality of zoning. And so we talked about the rational basis test and the fairly debatable standard and some of that kind of stuff. And we've also seen some of the procedural due process protections. If your property right or your property is going to be affected or taken by government decision, on a permit, for example, that you're entitled to some kind of notice and some kind of hearing. And so we've talked about that. Of course, many of the legal requirements that we've discussed, such as things like the land use nexus, and the requirement of substantial evidence on the record and findings, those go beyond what the Constitution requires. So those are requirements that are really arise out of state law, not out of the due process clause of the U.S. Constitution. But now what we're going to turn to is the takings clause and the I'm not quite sure why the projector is a little low, but anyway, so we're getting the bottom part of this cut off. I apologize. But we're going to turn to the takings clause, which is found in the Fifth Amendment to the U.S. Constitution. And it is made applicable to state and local governments through the 14th Amendment selective incorporation doctrine. So the Bill of Rights, the first 10 amendments, were really actually aimed initially at limiting federal government power. We had a brand new federal government at the time. And so, for example, the First Amendment starts out, Congress shall make no law respecting blah, 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 blah. So that's where you get free speech and free exercise and so forth. Okay, we all know, just as a matter of living in the U.S., that the Louisville Metro government cannot infringe on your free speech rights, can't establish an official Louisville Metro religion, can't interfere with your free exercise of religion, et cetera, right? We all know that, but that's not how the amendment starts. The First Amendment starts, Congress shall make no law respecting. Why? It was because there was a fear at the time that this new federal government with all of its power would infringe on individual rights and liberties and freedoms and so forth. And so that was the idea. Over time, the sort of understanding of sort of federalism and the relationship between federal and state and local governments shifted, especially after the Civil War, when you had we had a bunch of states secede from the Union, and we had a whole Civil War over it. And so part of what came out of the what we call the Civil War amendments, so they were amendments adopted after the Civil War, was this effort to have a more sort of unified national system of law and government and so forth. And so the 14th Amendment includes the Equal Protection Clause, okay? So that's actually where we got the Equal Protection Clause, is in the 14th Amendment, which is aimed at protecting rights and freedoms against states, and by extension to local governments, which are just subunits of the state. And there's a Due Process Clause in the 14th Amendment as well. So there's a Due Process Clause in the Fifth Amendment, there's one in the 14th Amendment. There is no takings clause in the 14th Amendment. Okay? But what has happened over time is that the U.S. Supreme Court has held that most, but not all, of the rights that are protected by the Bill of Rights. The first 10 amendments to the U.S. Constitution apply to the state and local governments, okay? And that's called the doctrine of selective incorporation. And they just sort of shoehorn it into the Due Process Clause of the 14th Amendment. Now, it goes the other way. The Equal Protection Clause applies to the federal government, even though that wasn't really the focus of the 14th Amendment. The focus of the 14th Amendment was protecting rights of people against the state and local government. So it's kind of worked both ways. The text of the Fifth Amendment is, nor shall private property be taken for public use without just compensation. And I said, nor shall private property be taken for public use without just compensation. Most legal texts can be what we call elementized. You can break it down into elements just by taking the text and breaking apart the parts. So the Takings Clause is a perfect example of it. There are 4 elements: private property, taken, public use, and just compensation. And so each of these are relevant to analyzing whether a taking has occurred and what must happen. So private property, of course, since this is a land use class, we're talking about land. And land is clearly ownership of land, property interest in land, including leases and easements and that kind of thing. Private property. Personal property, intellectual property, etc. These are also things that are protected. Water rights, etc. Now, I have said up here, private ownership of land gets the greatest protection. There's actually a Supreme Court decision that's come down in the last few years where the Supreme Court says that all property rights are protected and that non-land rights, interest in personal property and interest in water, get no less protection than interest in land. Okay, so they in other words, they all get equal degree of protection. So that's very nice for the Supreme Court to say that. They are, they're trying to make a point that, you can't just take commercial goods or people's water rights or that kind of thing without compensating and just say, well, that's not land, so, it's subject to more government control and regulation and so forth. Having said that, if you actually read all the cases, it is still a empirically true statement that land gets more protection. I mean, if you just watch what the cases say, what the outcomes say. So whether the Supreme Court agrees with that as a matter of legal theory, the reality is that there is an intense amount of attention to the protection of property interest in land, private property interest in land, that is highly relevant to what we do in land use planning and land use regulation. Okay? So, this screen thing is annoying me, but I don't know. Somehow or other they've adjusted the projector so it's projecting lower. But anyway, it is what it is. There's not a zoom out function, sorry. Let me see if I put any options down here. I will move it here. So no zoom out, sorry. All right, so we'll do the best we can. So private property, the first question is, do we have private property? And generally, when we have regulation of somebody's privately owned land, we do. The next question is, if there's been a taking, what kind of, what does the government owe? And the government owes just compensation. So first of all, the key point here is that if a government entity takes land or takes property, that's okay. There's nothing illegitimate about it. They just owe just compensation to the property owner. Okay? And the reason is because the local government has power of eminent domain. We're going to talk about that more in a bit. But what counts as just compensation? The basic rule is the fair market value of the property is what the government owes. This is an interesting area of law. There's a fair amount of litigation